Hey, how you doing?
Happy Friday, everyone. This is Attorney Ruben Restrepo here, and thank you so much for coming to the December meeting, free CLE here. If some people's name, did I get muted by accident?
Accident, yeah, sorry.
Okay, yeah. So thank you so much for showing up to the Harris County Municipal Justice Bar Association December meeting. I want to thank everybody for showing up. I'm going to be hosting it today. Feel free to put your name in the chat and along with your bar number, but this is self-reporting, so you guys can obviously go into texasbar.com and report it as well. But if you want us to do it, then it has to be in the chat. So I'm going to be hosting it today. I'm going to be hosting the CLE. Yay, I finally get to do something. So that is what we're going to do here. That's what I do. All right, so I'm about to share the screen and then we're going to kick this off. Okay, everybody can see the screen? Okay, so
Yes.
Today, what we have here is the driver's license suspension hearings, all right? Like I said before, I'm Ruben Restrepo. I'm a criminal defense attorney at Sulo and Sulo. For this year, I am the president of the Harris County Municipal Justice Bar Association. I am a graduate of South Texas College of Law. I am from Louisiana, originally from New Orleans, and my undergraduate degree is from the University of Louisiana in Lafayette. I worked a long time in finance, and then I decided to change my career and become a lawyer. And I am a criminal defense lawyer, and I love being a criminal defense lawyer. Okay, so let's talk about the driver's license suspension hearings. All right, so in the title, basically, I call it the non-DWI driver's license suspension hearings. That's because the DWI one is actually called the ALR, Administrative License Revocation Hearing. Those are completely different. We had a CLE about that one a while back. It's just somebody gets pulled over for a DWI or a DUI dealing with drugs. Pretty much that's what they're going to have to deal with when, you know, there's like an automatic suspension. These are the non-automatic suspensions. These are when you're dealing with somebody and they're trying to decide whether or not they're going to plead guilty, something along those lines. They're going to have this hearing. So when we're talking about what kind of suspensions you can get, there's the traffic. There's ones dealing with crashes, the DWLI, which is completely confusing, not DWI, but DWLI, which is driving with license invalid. There are alcohol related things and there are drug related suspensions. This is apart from the ALR, and then out of state offenses. So let's start with traffic offenses. 4 or more moving traffic violations within a 12-month period, or 7 or more moving traffic violations within a 24-month period. I think it used to be 36 months. It's kind of confusing because there was an old code before when we had the points, and then we had the new code. And so I couldn't really figure it out. I know the website for DPS says 24 months. So that's what I'm sticking to because that's what they're publishing. Or 2 violations conflicting with a restriction or an endorsement, right? So then that's a little bit of a squishing it in there. There are also some other stuff, other breakdowns when you're dealing with minors. Minors basically get one, and then the second one, they're just totally toast. But continuing on, we have crashes, right? Whenever somebody gets into a accident, a traffic collision, right? The officer is going to list the factors that indicate decline responsibility. So basically what that just means is that, it's like if they say failure to control speed, that's saying that that person kind of has liability, but they can just also just put in the accident report. So they're just kind of indicating it, and the indication is what's important, not the fact that they got the ticket. Not having insurance at the time of the crash is a big thing that ends up showing up a lot. And the reason that somebody will have a notice of suspension, which I'll talk about in a little bit. The crash resulted in injury, death, and or property damage over $1,000. The main thing that you need to know there is that it's basically going to be property damage, right? You're not really going to see all the rest of the stuff. Your license will be suspended, but if there's some kind of injury and with the accident, it's probably going to result in an actual, instead of a traffic offense type charge, they're probably going to be arrested, especially if there's a death. We're talking about like involuntary manslaughter or manslaughter or something along those lines. So people aren't too surprised when there's a license suspension for those. The surprise comes with a rear ending. You rear-ended somebody and there's $1,500 in damages. It's like, wait a minute, what's going on over here? Why am my license being suspended for this? Well, this is the reason why. Okay, so driving while license invalid. For that one, there's going to be a traffic stop. There's going to be a citation by law enforcement, a peace officer, somebody along those lines. And then there's going to be a conviction. So that's the big thing, right? Sometimes you actually get, somebody can have a suspension and then you find there's no conviction. So this is going to play a little bit later on in the defenses. But the main thing is that there's a conviction for a DWLI. As a lot of people here who deal with traffic know, paying a ticket is a conviction. A lot of people, the normal lay people don't know that, but paying the ticket is the same as pleading guilty. It's just you don't ever go in front of a judge. So you pay that ticket, bam. Even if it's not true, even if the circumstances didn't warrant it, guess what? You now are going to be subject to getting a suspension. All right, so alcohol. Again, this is apart from the ALR. So you might have won the ALR, but this could still be the consequences that you suffer. If you're 21 or older with a conviction, 12-hour DWI intervention program is going to be required. A 32-hour DWI repeat offender program is going to be required. $100 reinstatement fee, and you're going to need the SR22. I'm going to talk about that a little bit later. All right. For minors, 1 year suspension for the first, 18-month suspension for subsequent. If this is the subsequent, I guess, alcohol-related driving offense, right? So it's like, oh, it's the first one, you just get 1 year. Is this, oh, you've already had one? Well, guess what? Now you're going to get 18-month suspension. $100 reinstatement fee. SR22 is required. If it's drug related, it's going to be basically 6 months, 180 days, 15-hour drug education program. One thing to note about the program is that it is in person. They do not accept online stuff. Although I don't know if there's some kind of COVID exception right now, but that's what their statement is. They don't accept the online stuff. $100 reinstatement fee. SR22. Starting to notice a pattern here, right? Out-of-state offenses, right? Commit out-of-state offense and don't comply with the terms of the citation. Conviction of Texas equivalents. Texas obviously honors out-of-state suspensions, and we also honor if you haven't paid like any tickets. And so that can cause a lot of problems for people when they have something that's out of state and they're trying to figure out what's going on with that. Why is my license suspended? Why can't I renew my license? Well, have you taken care of all your tickets? Okay, so when you get a client, what you want to do is you want to figure out their license eligibility. So you can just Google it, say Texas license eligibility, but the actual website is txapps.texas.gov/txapp/txdps/DL eligibility/login.deal. That's the real version of it. And they call it a login, but the login is basically your driver's license number or the person's driver's license number, their date of birth, and the last four of their social. So obviously this is stuff that you want to collect when you're doing intake because you want to see what's going on with that one. All right. I did try to get an example of it, but every example I got had a person's name and I couldn't figure out how to redact it. So I was just like, let me just not even try it. I don't want to be sharing people's information. But basically, it'll talk about the eligibility. It'll talk about if there's any kind of suspension enforced. They call it enforcement actions that are out there for you to see. And so then you're going to be able to react to that one. You're going to be able to say, okay, well, you currently have this enforcement action. It also tells you ways to relieve the enforcement action. So one thing you're going to see a lot is SR 22 needed to be reported. But let's say if it's an accident, it might need something along like an SR 60 or an XR 19. It might say, well, they need an occupational driver's license, or they need to turn in proof of insurance. There's going to be something in there to tell you how to get rid of it. It also tells you the duration, the beginning and the end of the duration. Now, you can't be fooled by it though, because it might tell you the beginning and the end of the duration, but if you're disputing it to get a negative finding, to get a finding that's going to be favorable for your client, it's not actually going to end there. It's not actually even going to begin at that point. It's going to begin whenever the judge finds against your client. So that's something that's important. And then sometimes you see something ridiculous like it ends in the year 9,999. Obviously, nobody's going to live that long. That just means it's indefinite until an action is taken. Generally speaking, for that, that's going to be like something along the lines of putting down a bond amount to see whether or not the person is going to win or something along those lines. Okay. So what usually happens is somebody gets a notice of suspension, right? So they have the dates of the suspension and they have about 20 days to respond. So I have an example here. I've blocked out all the stuff, but as you can see, there's it tells you if it's a CDL, it's like no or yes, a CDL number. If it's no number, then it's going to be the driver's license number. Or if it's just going to have their ID. I'm not sure what UNL stands for. Maybe somebody else that's run across that can say. But we have the accident date and the location. So on this example, you can see it's like Harris County, and then it says it's suspended indefinitely. So that's kind of what I was talking about. Indefinitely doesn't mean it's forever. It just means that it can be forever if you never take any action, right? And then if you get pulled over, then you're going to have a ticket for DWLI. And so then you take care of the accident, but then pay the ticket. Well, now you're going to have another suspension hearing for a DWLI. So wonderful cycle that can mess up a lot of things. So that's something that you have to worry about for your clients, and you're trying to think about it a little bit further. So like I said, intake, what do you really want to get from the client? It's a lot of basic things: their name, their driver's license number, their date of birth, their address, their phone number, and a county of residence. The main reason you need all this stuff is because you're gonna put all this in an email and say, hey, I'm representing these people, here's all their information, and then you're gonna request everything else from there. All right. So like I said, after you've taken all the information on the intake for your client, you've done the license eligibility, you've looked at their notice of suspension that they received. And that's the big thing about the notice of suspension. It's not something that we receive as attorneys. The only reason they're coming to us is because they received it in the mail. So we're going to be reacting to that, and we're going to be using that to say, hey, here's the cause number. One thing I can say is that the cause number is generally their license number, right? It could be their ID number if they don't have a license, but I haven't seen that, honestly. So what are we doing? Requesting a hearing. You're just going to send an email over to hearings@dps.texas.gov. And you're going to give all that information, but also you're going to give information of yourself, right? An attorney of record, your name, address, phone number, fax, because you want them to be responding to you, sending you the information, because it is something that can happen where they're just, DPS sometimes will just be oblivious and keep sending them information. And then you're trying to figure out when stuff is happening, and you're trying to call them up, and they're like, we've already sent all this. No, you didn't. I sent you the information. I'm the attorney. You got to send it over to me. So that's something that you got to be cognizant of when you're requesting these hearings. Basically, what I would do is you could just set up like a signature on Outlook with all the same information, or just a little template on something. You copy, you paste it, and then you just fill in the blank every time, and you send it directly to hearings@dps.texas.gov. All right, so now you've done this. What you should expect next is something called the notice of hearing. The notice of hearing is DPS should send a notice of hearing. It's going to give the location of the hearing, followed by a notice to appear from the court. However, it may be missing the petition. Okay, so this is a weird thing that happens. So DPS has to tell you the date that everything is going to happen, right? It's going to tell you the hearing. That's the main thing that they're responsible for, right? This is all very, very automatic, okay? This is not a situation where it's basically an attorney or an assistant for DPS that's handling all this stuff. It's very computerized. So if they get the information, and then somebody says, oh, okay, this person is now represented, once the hearing date is on there, it's like it's so computer generated, so robotic, that I've literally just seen 4 of them just look exactly the same. It's just insert name here, insert name there, insert location here. And that's all they end up sending you, the notice of hearing, right? And so it's like, oh, okay. But then once that part is done, it's like the court ends up taking over, and they end up sending you notices of hearings, but they send you mainly notices of appearance. And so that's kind of the main difference. So you want to be cognizant, though, getting a notice of hearing isn't the same thing as having everything that you need. So one thing I kind of compare it to is if you're doing a probate, and let's say you're an ad litem, you get appointed, the applicant is supposed to send you the application. They're supposed to send you the petition that they created. Yes, the court can send it to you, but the real person that's responsible is whoever wrote up the petition, right? They're responsible for that. But because what they're supposed to send you first is the notice of the hearing, so that hey, you got to show up here, they actually can forget to send you the petition. So sometimes you get 3 papers, you get a notice of a hearing, the petition, which is basically 2 different papers along with it, or you'll just get the notice of hearing. So that's something that you got to be thinking about. Did you get everything? Okay, so your next step after you do that, report it to yourself, you want to say something along the lines of requests for discovery, right? So this is very similar to just anything else. Now, this is an administrative process. So we're talking about the Texas Rules of Civil Procedure here, not our normal criminal procedure manual stuff. So you're going to be requesting, you have to request it, but I mean, it's kind of the same thing, but you're not going to be entering in like a Michael Morton Article 3914. That's not going to happen. You're just going to say, hey, I need a production of all the records that DPS intends to introduce. And that should be enough, right? Now, if you didn't get the petition, one thing you might want to think about is actually saying, and the petition. But it's a strategy. Everybody's a little bit different, because if you didn't get the petition, it's a little bit like a traffic citation. If there's no citation, is there anything we're talking about here? If there's no complaint, why are we here? So that's something that you want to think about. But I'm also going to talk about how judges can be in these cases. So that's why you might want to take that advantage of the opportunity and be like, oh, you didn't send me the petition, I need that petition as well. Because if they still forget to send you the petition, that's going to be advantageous for you to say, hey, I asked for the petition, I still didn't get it. So, and here's my proof. So discovery, petition, I'm harping on this petition. I didn't realize I was going to harp it on it so much, but it's from experience. It's needed for the allegation, usually references the transportation code, and it's very robotic in nature. No one is going in there and copying and pasting. It's literally it just spits out. When you see enough of these, they'll use the same exact language. So you can tell that it's some kind of program saying like, oh, this is what DPS noticed. This is the petition that it's going to come up. So the other thing that you should expect is a DPS abstract driving record. Now, this is very different than the driving record, okay? So this reflects enforcement actions, which is not on the self-ordered driving record, okay? The driver responsibility program, I think that one is on the self-driving one and or the self-ordered one, and the event history. The other thing I think is that it shows surcharges, which is not really a thing, but it can help you kind of sift through certain parts of the driving record. And you could see it's like, okay, somebody had surcharges that were owed at this time, which is why they had a DWLI, or what would have made their license invalid at the time. And then they got a ticket, and then they got a conviction, and then a big problem. So ordering the self-ordered one is not going to be as helpful as the one that is provided by DPS, which is the abstract driving record. Okay, the other thing that you should expect is non-standard discovery. So this is stuff that you can kind of go out and look, or stuff that they can provide you. It's just really going to depend on whoever the DPS person is. But if you go look out for the tickets, that can really help you out to see kind of what happened. A lot of times you'll run into an accident case, and your client basically has no accident on their record, but they're alleging an accident that they're supposed to pay. And you look at the ticket, and they didn't get the liability. What they got was failure to maintain financial responsibility. But that doesn't show up because they didn't check the box of unable to verify. So then it got dismissed, but you need to be able to see that so that you can create that argument in the hearing by saying, we're not relitigating this. They don't have the proof. End of story. But with the proof that they just give you, sometimes you just don't know what they're talking about. Accident reports, They don't always turn into accident reports, but if they do, then that's mainly where they're going to get that indication that it was your client's fault on a crash suspension hearing. Insurance company receipts. They don't always give this one, but they should. If they're alleging that it cost $3,000 something, basically if it's over $1,000, where's the proof that it actually cost that? Remember, a petition, that's this is civil, so a petition is not evidence. So where's the evidence for that? You should be able to give me some kind of evidence for that. Okay, so let's review the discovery. We're reviewing the petition for the dates and the times. Again, you can look at the abstract driving record and it'll kind of give you an indication, but the main thing is going to come from the petition. Petition is going to be very specific. The accident happened on this day, you know, because if the abstract record doesn't even have the accident on it, you don't even know what you're fighting. And you're kind of asking your client questions like, hey, when did you have an accident? They may not even remember, because a lot of this stuff is very old. Review enforcement actions for reference to events. So that is kind of a big deal right there. So if you're reviewing the enforcement actions, a lot of times they'll say related event. Mainly on the traffic stuff, you're going to see that when they have the 4 consecutive, 12 consecutive months, 4 within a 12 consecutive month period, or within the 7 within a 24-month period. When you see that, that's going to be like, oh, okay, wait a minute. I see it right here. Event 3, event 4, event 6, event 7, you know, and you'll be able to kind of piece it together. One thing to note, dismissed cases won't show up under events. So that's why we fight so hard to get the cases dismissed. Even the deferred disposition, dismissal, DSC, the only thing that'll show is the DSC, not the actual case. So then that means that the event won't show up. Dismissed accidents will prevent accident events from showing as well. So a lot of times if there's some kind of accident, it'll say crash or it'll say accident, something along those lines that's being reported. If it was this, if it was a failure to control speed or failure to yield right away, and that got dismissed, it won't even show up, which is advantageous for us in getting it, getting a finding that we want. All right, so let's talk about the hearing. The judge will not relitigate the facts. So it's just going to start off, and the judge is going to be like, "Hey," he's going to say, "This is from DPS versus client." And they're going to mainly say, we're not relitigating the facts. They're not going to try and go into it. So it's a lot of fast talking. It's a civil rule, so it's preponderance of the evidence. And it's what I call a paper case, very similar to an ALR where all they need is the paperwork and they just submit it. A lot of times the DPS attorney doesn't even say anything. They're just kind of like, bam, I rest my case. Look at what's going on right here. They haven't reviewed it that much, you know. To them, it's just like, do they tick off the stuff? Judges also get very used to this stuff, you know, because it's so robotic in nature that you kind of have to really be ready for how they're going to talk. So DPS, they're usually just going to read the petition, introduce any kind of evidence, usually the abstract record, and then, like I said, there's usually no arguments. Because it's all based on the documents. Okay. So when you're trying to defend this, basically my strategy tends to be object, right? I object to the failure to provide a petition. No, I'm not standing for that. If I never received it, it doesn't exist. I don't know what's going on. I usually, for me, I usually do a lot of Harris County stuff. So I go into Odyssey and I try to see, is the petition part of one of the documents? If not, then I'm questioning whether or not the court even has it. Because if the court doesn't have it, then it's not even a real thing. It's just, oh, the petition was filed. No, maybe only the notice to appear was filed. So that's one thing that you can object to, say, hey, there's no petition here. And you can basically say the petition, it's not evidence. They didn't do what they were supposed to do. I want a dismissal. I don't even want to go forward with a finding. I just want a straight up dismissal on this, because they can always refile. And a lot of times they just don't want to refile. I reiterate, petition is not evidence. So a lot of times they go in there and they say, oh, well, this is what happened. There was an accident. It was on this date. And we're alleging that it was $3,000 something. And they haven't shown us proof that they paid it. They haven't showed us proof of insurance. And I'm like, well, your abstract record doesn't show that there was a ticket for not having a failed to maintain responsibility. So I don't know where you're getting this from. I don't even see an accident on the abstract record. What are you talking about? This is a missing event, and you're referencing it because it's on your petition. That's not evidence. So I object to them referencing anything without evidence. Argue there's no evidence of an accident. I object to shifting the burden of proof. This happens a lot. They say, well, they were supposed to turn in an SR-22, or they were supposed to show us that they had insurance documents on that date, which is definitely a defense. But why do I have to show that if they don't even have a ticket? Right? This isn't, again, we're not relitigating it. If they don't even have a ticket, why do I have to show that? Nope. Objection, Your Honor. This is shifting the burden of proof. This is DPS's action. This is DPS's petition. They have to show a scintilla of evidence, at least, to even go forward with this. And here they have no evidence. Another thing, like, let's say it's a traffic deal. Sometimes you'll see speeding. So if they get 4 tickets and one of them is, let's say 3 of them are speeding, but 2 of them say 10% or above. One of them just say speeding. Guess what? I'm not accepting that, because it has to say 10% or above. Because if it's less than 10%, it's literally not a moving violation by the code. And if it's not a moving violation, then that just means the computer recognized the word speeding and spit it out. So I'm not going to accept that. That's basically a wrong event. That's and I object to those things. The other thing is mainly doing a prevent defense with this stuff. And what can you expect? You can expect a lot of probations, because I could say a lot of these defenses, but then a lot of the times they just kind of got us dead to rights. It'll all be in the abstract record. Everything will be just clear as day. And it's like, okay. So what I try to do is I try to prevent it. And I try to, if I feel like I'm going towards a loss, I try to go steer it towards a probation. Okay, so what do I do for the prevent defense? I use the petition to look up the accidents. And that's how I'm able to kind of like piece together kind of what happened. Was it dealing with failure to maintain a financial responsibility, or were they actually at fault? So if it's the 12 consecutive months, when was that? How long ago was that, right? So one thing I gotta point out is the 12 consecutive months are based on when the ticket was issued. So if you have a client that just paid a bunch of tickets, right, because they're trying to renew their license, they literally could be paying some very old tickets from 2009, and now we're fighting. Well, they got 4 tickets in 2009, and you're like, really? Why are we here? This isn't something new, which, by the way, is a really good defense. But that's something you have to think about. It's not when they paid the ticket, right? Like, they just paid 4 tickets consecutively. No, that doesn't matter. The only matters is when that officer wrote those tickets, because that's what you're looking for in the event portion of the abstract record. Convictions, and when they were, are they within 12 months of each other? I have my clients pay the reinstatement fee, the $100 a lot of the times. I say, look, just pay that, because if we lose, then it's already paid and we're kind of just able to go forward. And then I get them to get the SR-22 anyways. because a lot of times you'll find that the judge they know that our client didn't have the license, didn't have the insurance. They're expecting that, right? And so, and especially when you've looked at everything and everything's just going to go against you. If you have them already do this stuff, then it's so easy just to get a probation and you don't have anything to worry about from there, right? Especially if the client's at fault. If they were at fault, get them to file on their insurance. A lot of times clients have insurance and they didn't have it on that day and the cop gave them a ticket, thus starting everything. Or maybe they were driving their brother's car and they have insurance on their own car and they forget to, because the cop is like, no, well, this car didn't have insurance, right? It's like, yeah, but I have insurance. And like, now too late, write the ticket. And then even though this person's saying, hey, I have insurance, they don't give this other person that insurance, right? Because usually it's the police officer who gives the insurance to the other person. Well, then guess what? Now our client is going through that other person has never filed a claim against the client's insurance. So get them to file the insurance claim. If it's denied, then you can go to the next part, which is settle with the other insurance company, right? They can basically do a reduced amount, or they can do a payment plan. Now, if it's a payment plan, they got to file an SR-19. They got to say, this is what we've come together with, and got to get notarized. And they're sending all of this to DPS, idealistically before the hearing. But it could be a ruling that, hey, they have to do this stuff anyways. If you do that, a lot of times DPS will actually just dismiss it, or they'll just be put on probation with an affirmative finding. If it's an accident that's more than 2 years old, right? So sometimes what will happen is that everything will take so long that it's almost 2 years, and then you end up getting a reset. Now it's over 2 years. It's like, oh, okay. Well, guess what? Get them to pay the reinstatement fee, file an SR-22, and then they're going to have to file something called an SR-60, saying that that other party failed to sue me for their $3,000 or $2,000. So I don't have to put a bond down, right? And it is a bond. What it is that you put this bond down, and then you can reclaim it after 2 years after you file an SR-60. But I'd rather my clients never put any of that kind of money down, because a lot of times what will just happen is they'll be like, I don't have the money. And so then they'll just be an affirmative finding, and then they won't have any. It'll be indefinitely suspended until 2 years, and then they have to file the SR-60 anyways. So obviously, if it's over 2 years, just fill out the SR-60, turn in the SR-22, pay the reinstatement fee. And if they feel like they're not going to make any kind of payment, then that's it. You don't need to go any further. If they're going to make some kind of payment, that's on them. Okay. Other winning strategies. It's just too old. A lot of times the stuff is just too old. Accident more than 2 years old. Checking the year of the events, like I mentioned earlier, if it's from 2014, like, what are we doing here, Judge? I get it. DPS does this automatically, but why are we here? We really don't need this stuff. This person was trying to get their stuff straight. They got their stuff straight. Now they were able to get their license, and now you want to take their license away? Come on, get out of here. This is too old. A lot of judges are just like, you're right. Negative finding, go away. Come on, don't make me suffer, right? Don't make me suffer the consequences of doing the right thing, of paying tickets. Well, where I see this a lot is it's in a county, Chambers County. It's like, I don't know, they're Chambers County, and they're trying to call them up and work it out, but they can't get it worked out because they can't go over there. And the only time that they work anything out is a day of a trial, and they don't want to set it for trial, so they just end up paying the tickets, causing their problems, paying the DWLI ticket. Darn. So, or paying 4 tickets because they used to live there, now they don't live there anymore. Remember, if it's reset beyond 2 years, just file the SR-60. Petition missing, again, if it's missing, this is not even a real action. If there's missing certain evidence, and force a refile. Sometimes forcing a refile is the best way to do it. You've reset it, you reset it, you reset it. You can't get it over to 2 years. but they forgot the whole time. They've forgotten to give you the petition. You say, okay, well, there's no petition, so I don't know why we're here. The judge is literally going to point out, well, they're just going to refile on you. Okay. Then you just go through it all again, get to 2 years, SR 60, bam. Now you don't have to worry about your client who probably can't afford to pay $500 to whomever, and that's how you're able to do it. Rulings. There's an affirmative ruling, which is basically a loss, right? It's weird. It's like yes means no for us. So licenses will be suspended for the time stated on the notice of suspension. License suspended indefinitely until bond paid or the 2 years passed. Pay reinstatement fee. The reinstatement fee is just always going to come in there. Then there's the win, even though it's a loss, right? It's called affirmative, but you get probation. So it's affirmative probation. You pay the reinstatement fee. It can be up to 1 year. Generally, it's not. It could be like 6 months. It's basically treated as a deferred disposition. Anybody under 21, they're going to have to do a driver safety course, just plain and simple. A negative finding, defense wins. Woohoo! Reimbursement of the reinstatement fee, if they have that. So if they've already paid it, great. They're going to get their money back. What I see a lot of times is that judges lean towards the probation, right? It really has to be something egregious and it has to be like, if it's the tickets, if it's a traffic deal, it has to be very, very recent where they're just going to be like, you know what, this person's stuff just needs to be suspended, right? And if it's a technicality, if it's like not that old, but it's, so it's recent enough, then they're going to put them on probation. They're going to lean more towards a probation. Minors really suffer from this. I think minors, there's anybody under 21, so it's kind of like, oh, come on, this person's 19 years old. They're a good person. What are you doing? It's a criminal age, so they just tend to just automatically give them that affirmative probation, because it does tend to go towards that -2. I know for sure if you get anything and you're under 18, it's just like you just get the 1, then that's just going to be it, right? You get that second ticket, they're not gonna really go with you. Although sometimes if you got the ticket when you were 16, 17 years old, and now you're 24, it's that strategy of it's just too old. Okay, so what I'm going to do now is I'm going to stop the share. All right, and let's go for questions. So anybody have any questions?
Yeah, Ruben, I put something in the chat to the effect, is this abstract record different and more evocative, shall we say, than the type AR record? Does it show stuff the AR does not?
AR, I'm trying to.
The type AR is the certified driving record.
Oh, the one that you ordered, the self-order one?
Yeah, you can order
Yeah,
it, yes.
it is very different. The main thing is that it's going to show the surcharges and it will show the events. So every time that there was some kind of hearing scheduled, even if it was just scheduled and never went through, it'll show those hearings in there. And it shows the related events. So that's the one thing that you will not see on your regular record. You'll get your record. It'll show you every time you've taken a driver safety course and turned it in. And it'll show you your event. So any convictions. But things will definitely be missing, like any kind of surcharges that you were supposed to pay. None of those stuff will show up. So I've literally, I used to have my clients just say, oh, well, just give me your driving record. And but then one time I had two different, the abstract record and the self-order one. The self-order one was like 2 pages. The other one was like 5 pages. And I was like, what is going on? And it was because there were so many surcharges on there. And it was just one of those things where it's like for years that he had a DWLI for a status as his license because of the surcharges. Then when the law changed, it all went away. And then he just had tickets to pay. So he was like, oh, I can get my license back, pay the tickets, but then got his license suspended, got the notice of suspension because he paid the tickets instead of getting a lawyer from Harris County Municipal Justice Bar Association to get him dismissed. Shame on him, but not shame on him because that means that we got some money. So that is the main thing. You want to request that, you want to demand that because you just turn it right around and just say, what are you talking about? It's not right here, Your Honor.
I understand that, but I guess what I'm getting at is, are you saying in essence that the department is reaching back in time to when surcharges made a difference and anybody gave a damn to keep people from getting their license renewed or to take their license away?
Yes.
Even though the program is gone?
Yes, because that's why I said it's actually robotic, right? You pay those tickets. Then let's say there was one in March, then April, then another one in November, and then December, right? And this was all in 2009, right? And because they were having so much problems with tickets, they ended up getting a surcharge. And then because they had a surcharge and they didn't pay it, they got another surcharge. So then there's like 19 different surcharges, insane amount of surcharges. So they never even bothered with the tickets because they couldn't even pay the surcharge. Well, the law changed, all of the surcharges are forgiven. They're like, great, now let me get rid of these tickets because they're trying to renew and get their license. Because before they had to pay $4,000 or some stupid amount of money where they could never pay to get their driver's license, right? Well, now all they have to do is apply for their driver's license. Oh, wait a minute, you have outstanding tickets. So they end up paying the outstanding tickets. And then from 2009, those 4, maybe 3 of them were paid, and then they paid that last one. Well, now it looks very weird. It's like from 2009, you have 3 tickets paid, convictions are in 2009, and then there's one little bitty ticket that says 2021. Well, when were they issued? Within 12 consecutive months of 2009. And actually, the funny thing is, that wasn't even the law, right? It wasn't like, within 4 tickets, it was points back then. So that's why it's like, hey, this is too old. That's why it's a good defense, because it's too old. But no one at DPS looks at it. They literally do not look at it until the date of the hearing, right? And like sometimes I'm like calling them up. I tried this before. I've called them up and say, hey man, let's get rid of this ticket. And they're like, I'm not even on the case. Okay. So that means it's only the person that's on the case on the date of. Now, one thing I didn't talk about is that right now there's a lot of Zoom hearings. So, and I don't think they're going to get off of the Zoom hearings. I think they love the Zoom hearings. It's just so easy, just like click, 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 click. Sometimes I'm on a Zoom hearing for like an hour, and then they come up and they say, hey, there was a negative finding on your case. You can disconnect. Great. I didn't even have to make an argument. So there's a lot of Zoom hearings, but before we had to show up, and there was like, 30 people in the court, and then 10 attorneys. And and then it was just a very, very long wait. And then we quickly go up in front of a judge. But whenever we had that, we could always just go to the DPS and say, hey, did you notice this is from 2009? And they go, what, really? Dismiss this case. And bam, you're just able to go home. But now there's a Zoom, you don't even get to talk to them. One time I tried to say, hey, can I get in a breakout room, talk with DPS, point out something that I think is going to make them dismiss it? They just told me no. I'm like, nope. I was like, okay. So I had to wait until I was in front of the judge. And then the judge, I asked again, and the judge was like, nah, we're just going to go into it. I was like, okay, cool. We started it, and I said, judges from 2009. So obviously I had one from 2009, but I also had one from like 2012, 2013, 2011. But I was like, judge is super old. Judge is like, oh, okay, dismiss the case. Well, actually, they make the ruling. They go, oh, if it's okay with DPS, I'm just going to do a negative finding. And then DPS is like, yeah, it's fine. So a lot of times it'll happen like that, but it is really strange because they'll just go in there and they'll just say they had 4 consecutive tickets. They're making the arguments of 4 consecutive tickets within 12 months. Bam. Okay. It was in 2009. Oh, really? Oh. So it's kind of that situation because it's robotic. It is not a person who is literally looking at this stuff, right? So that's why it's so important for clients to have an attorney, because the ones that don't have an attorney, they're not dismissing those. And then DPS goes in there and says, this problem, the person's going to have to pay the fine. They're going to have to pay the SR 22. And then that's just going to be it. And then so it'll be an affirmative finding, but usually they do get a probation if it's really old.
Okay, Ruben.
Yes, Steve.
Okay, listen, yeah. When you were back talking about the DPS case and go to the defense, you mentioned very quickly, well, then go to Odyssey. What is Odyssey?
Okay, so Harris, this is not the same thing for everybody, right? So this is Harris County. The JP court, generally these are in JP courts. I have had like 5 in like Humboldt court. So Humboldt municipal court, but mainly they're going to be in the JP courts. So whenever you're trying to look up the tickets, well, actually, I shouldn't say it like that. This particular stuff is going to be at like the main one that I see is in the 3-2 out in Baytown, right? So when you're looking up the stuff, the case, you use the Justice of the Peace website, which is actually just Odyssey. That's the actual program. Fort Bend County actually uses that for their criminal department. So that's why I use Odyssey. I said the term Odyssey. I actually have just give me a second here. Close this out. Let me see if I can share that on my screen.
Well, as you're doing that, you're saying go to the JP website, whatever means Odyssey or something. The JP website's going to show all this discovery as to what they have.
No. Okay, so if you can see my screen right here, what I do is I actually save these in my favorites, so it's very easy to just go there. So JP Odyssey portal.harriscountytx.gov, Odyssey portal JP. Now, if anybody's been having problems logging into this, it may be because before 2021, it was just Odyssey portal.harriscountytx.gov. Somewhere along the lines, it changed to JP Odyssey portal.harriscounty.gov. But basically, you just go into the smart search. You can enter your client's name, and then you'll see a bunch of stuff. The notice to appear, not the notice of a hearing, but the notice to appear, will have the cause number. So if you have that, then you can input it here. I wish I had one I could show you, but essentially the document or the website, when you pull it up, there is something on the side that says document. When you click on document, it'll bring you down and it'll show you all the uploaded images. You can go through it, but you can also go through, there's a portion. Gosh, let me see if I can. No.
At any rate, the best time to ask for all these things was in your initial request for a hearing, correct?
No, so this is separate. This is these are steps that you can take in order to get the discovery. Because like I said, sometimes you don't even have the petition. So you're just literally talking to your client, and the client is the only one that knows what happened. And so then you're trying to use this stuff to, this is how you can basically do like your kind of your own investigation. It's a great way to find the original, especially if it was a JP citation. You can find that citation. The other place you can, obviously, if it's a Harris County, it could also be Houston Municipal Court. So you can use C-Smart to look for that one. And if you want to, I'll show you that. What it is it's called events. There's a events and hearings tab, right? And under there's always, if it's a ticket, it says case filed. But if it's a, if it's this stuff is going to say in Ray client name. So it's going to say petition instead of case filed. So if there's no document there, that means the court didn't upload the document. So the court should have gotten the petition, but sometimes they didn't get the petition. Sometimes they got the notice of the hearing. They basically got a request. And like I said, because it's a program. I'd say robot, right? But it's a program. It's a software that shoots off emails and stuff. And so somebody physically didn't go in there, create the petition and send it to the court and file it with the court. They're supposed to use e-file to file it, and they didn't. And so that's one way that you can do it, that you can basically win. Now,
Well,
the
you
court's not
have
gonna
to
like when you do that. I'll just admit that straight up, because they're going to say, well, this is just going to be refiled.
exactly, and you make a good point, but you have to ask for it so you can say, hey, they didn't get it to me, and I asked for it. I'm asking for the timing on this. Do we wait for our notice of hearing and then ask for the stuff that we could have asked for to begin with? And if so, do we
The
send it to
answer
whom?
for-
The DPS.hearings. something or other?
Hearings at dps.texas.gov.
When we make that request, that's where
You
we send
can
it.
you can request
again.
it there. Now, I'll tell you the drawback that when you do it there is you're just requesting a hearing. No one is assigned to the case. So like you can use that in front of the judge and say, Judge, at the same time I requested it, but they're going to be like, well, no one was assigned to the case because technically there wasn't a cause number. Now, well, I can't really say that. Well, there wasn't a cause number with the court, but there is like a citation number, which is the driver's license number.
Yeah.
So technically they are supposed to just give you whatever, right? But generally I wait until there is a notice of hearing, because that means now we're really in the court's realm. And we can use all the civil procedure stuff. Said, hey, I asked for this and I didn't get it. So that's kind of the main thing. It's like I'm looking for the petition and I'm looking for the discovery. Generally, the discovery will be the petition plus the abstract record.
And you send that request again to the hearings at DPS.subject.
No, you send it.
No. There's going to be somebody assigned to it.
To the
All that
court.
stuff. They will reply with the information. And
Okay.
it's usually a different email
Okay.
or a
Okay.
fax.
Cynthia, what was that you're saying?
Oh, I was saying that used to there'd be one person at the DPS, like in Baytown for Judge Bates, and then there were two. And so I'd send it to everyone. I'd send it to all of them that they're for Baytown, and then this last one last week, they've got somebody new there. So they don't look at anything you've done in the past. DPS doesn't forward it to them. So you got to do the discovery to the agent that's at the court that you're going to be at, that's assigned to your case. So I didn't get the discovery till 3 days before and found out there was a interlock ignition still on their record. And they tried to use that against me, and I was able to get the court to remove it. It should have been removed. So it was quite,
Okay, thanks. The
Technical.
answer is you send everything to the court that it's landing in.
but no,
Good.
to DPS, not to the court. The court doesn't, you gotta find out who the DPS officer is handling
At that
officers
court.
there for that court, and send it.
Gotcha.
They'll give you their email, and I emailed
Okay.
them.
You got it. Yeah, there you go. Thanks.
Okay. It's very important. You got to look at what they've got.
Yeah, David, I remember a long time ago, I looked it up, so I actually did read it, but I'm not sure of the citation for it. And actually, I'm not sure if it's in the transportation code. It actually might be in the admin code.
Somebody responded on the chat, and it's, yeah, it's Texas Administrative Code 15.89, and then they have a graphic, they call it. It's just a list of all the deals, but the definition itself is at 15.89.
Okay, yeah. All right, let me see if there were any other questions.
Yes, I have a question.
Yes, go ahead.
Yeah, does it make a difference if the claimant is the city of Houston? My understanding, there's not a statute of limitations regarding the city of Houston, and you said there's a 2-year wait period for.
The only people should be, well, I'm confused by your question where you said the claimant. The only people that can bring this action is DPS, because they're in charge. The affirmative finding is going to say, we affirmatively find that DPS has the permission to suspend the license. Right now, if you're talking about the people who are by claimant, did you mean the accident party?
Yes, the other party who was not at fault.
It doesn't matter who it is, right?
Doesn't
The other
matter.
party, well, let's be careful here. DPS can bring this action and make it like your client is at fault. I have definitely had clients who basically were rear-ended, but they didn't have insurance. So then the person files in, they file on their own insurance, and then that insurance company tries to subrogate, and they can't because there's no insurance company to subrogate to. And so then my client ends up being like, wait a minute, I was rear-ended, but because they didn't file on the insurance company, the insurance company basically never got to speak to them and only got one side of the story. So then what I do for that is I tell my clients, call that insurance company and just say, hey, you have a claim, correct? Yes. Okay, I want to file to get my car fixed under your claim. And then the insurance company goes, no fault. And then that's it. The whole thing goes away.
Okay, well, my question is more along the lines of that. The 2-year, I assume, is they're talking about the statute of limitations. So
yeah, it's a 2-year statute of limitations.
Nobody has brought a claim for damages within that 2-year period. I
Exactly.
think that's what it's speaking to. So, but if it was a city of Houston claimant, they got forever to file their cause of action, and I don't know how that impinges on the 2-year wait period.
Can somebody help me with that? I've never heard of that. They have forever.
Well, they don't have a statute of limitations. The city doesn't. It's my
Earl, what are you saying, Earl?
the city does not have.
Yes, they do. Here's what you do. There's a form that you can get from DPS, and that form just very simply says this case is over 2 years old. They didn't
That's
file
the
a petition
SR60.
within the time frame. This case is over with, and DPS will not enforce it. Done. I don't care if it's city of Houston, city of San Antonio, city of Corpus Christi, you're done, period.
I understand, but that's a city of Houston. I mean,
Okay.
You
So
keep
I think
dwelling
the way
on
to
this.
Think about it.
no, well, they can do that. but
This
the city
is the
of Houston
thing.
the city of Houston could still sue you after that.
Right. But when we're talking about this administration deal, the SR60 specifically states that if it didn't happen within 2 years, that's it.
That's it.
So I guess it's the assumption that's going on is that it's 2 year, that the statute of limitation is 2 years, right?
Right.
So what you would want to do is you would basically just ignore the fact that maybe the municipality doesn't have to wait that long, can get more than 2 years. It's simple. Once you file the document, you're like, hey, I have this document right here with the DPS, and it says they did not do it within 2 years. You know what? Let me look that up. Earl, why don't you speak and I'll look up the SR60.
Yeah, okay. I think what Mr. Munoz is referring to is for a municipality, there is a different type of a statute of limitations. I vaguely recall what he's talking about. It's not a forever, but he is right. There is something there that gives a municipality some kind of an additional time permissive action. It will not lie with DPS. DPS will not honor it. But what Mr. Munoz is saying, the city is still going to go forward on the basis of the fact of their sovereign municipality, or whatever you want to call it. That I think that's what he's referring to. And
Okay.
I believe that that's what he's referring to.
Yeah.
The truth of the matter is, it's still the same, Mr. Munoz, that DPS will not honor that. Now, as far as a subsequent civil action, I cannot comment on that. That you'd have to check with somebody that's a personal injury expert. But as far as the driver's license is concerned, DPS will not enforce anything beyond the 2 years. I don't know if I'm answering your question correctly.
Yeah, you are.
Right. So
Yeah, but my
the
conclusion
main
is
thing is for the
theoretical.
DPS, what you're going to do is you're going to have this SR60, right? And then it's an application for reinstatement of driver's license registration under the Safety Responsibility Act. Case number is going to be the driver's license. The undersigned, which is the client, they were involved in an accident in or near Harris County on this date. That 2 years have elapsed. There are no unpaid judgments arising, and there are no actions begun within the 2 years of the accident and any of the state courts arising from the above described accidents. Undersigned makes this affidavit, privileges, section 601.162, Safety Responsibility Act. And then they just fill it out. $100 reinstatement fee is required when filed. Now, like I said, if they have already paid that fee, then they just need to send off this document. And then, so that's what the strategy would be to get to win this. All you got to do is win this. Now, representing them against the city of Houston,
Let me
they didn't hire me for that.
Let me pose this quick scenario out, okay? Say you go through the DPS and they haven't filed anything. You win that case, okay? Because 2 years have gone by, okay? The third year, the city of Houston sues you for the damages. They get a judgment against you and they abstract it. They send it to DPS and say, this guy was at fault or this lady was at fault. He had no insurance, suspend their license. Now, is that a possibility in theory?
No. And if I could just jump in here for a second, Ruben, the answer is no. DPS will not honor it. What Ruben has just presented to you is golden rule. There are no exceptions to that. Now, as far as a subsequent civil action, and you're saying that they went and got the judgment, you can attack that judgment with a civil attorney. He can attack that judgment and just say what they did was not exactly legal. There is vague stuff. I understand what you're saying because I know that you've seen this and I have seen it too.
Yes.
But the truth of the matter is what we're here for today and the purposes of this CLE has to do with the license suspension. DPS will not honor the scenario that you just said. They will not.
So,
and you can check with DPS legal to see that, and they'll confirm this for me.
okay, so
well,
before we go on with any other questions or scenarios, I want to, for anybody who's self-reporting, the course number is 174143769.
I'm sorry, you were garbled there.
174143769. If you got If you got the email, it's in the email. It should also be in the Facebook post as well.
Okay, Ruben, all along you talked about if they didn't do that, and then you were talking about what's on the SR60 application form. When you say do that, are those the two paragraphs you're talking about, or are you saying they didn't go to the DPS saying this guy owes me and he didn't have insurance within 2 years? Which is it?
Okay, so what I do, the first thing I do when it's an accident case is I end up going on, I find out what county it was in, right? If it's Chambers County, oh, I'm gonna have a tough time. If it's Harris County though, that's real easy because all I have to do is search the JP Court's website, search the county court website, and search the district court website. If all under civil actions. If I don't see anything with my client's name as a defendant in a civil action, or the other party, which the way that you would get it for the other party is, y'all give me a second. I had surgery recently, so I'm having a little pain point. I forgot what I was saying.
The plaintiff. How to find their
The
names.
accident report will have the other party's name. So look at the accident report, and then and you can use that as plaintiff to search for that. If you see, you're gonna, majority of the time, you're gonna see nothing, because this is what happens. They file under their insurance company. Their insurance company, instead of doing anything, they immediately send it off to some law firm. That law firm is really just a collection agency. They don't go litigation or anything like that. And so what they do is they immediately send it over to DPS, right? What you would think is that they would try to reach out, but they don't try to reach out. They don't try to do anything. And actually, most of the time, the insurance company, they don't even try to reach out to your client, right? Like I said, I give you an example of, I had a client who actually had insurance. They never tried to reach out to him to try and find out who was his insurance. They just saw the accident report that the police officer wrote that he had no insurance. And so they believed it. And then so it just all happened so automatic. But then the client's coming to me and saying, hey, my license is getting suspended. And he's like, I don't understand why. They're talking about this accident, but nobody's ever filed a claim. I'm like, oh, so you had insurance. Okay, well, call up your insurance, handle it. And then it all ended up going away. So that's why I mean, like, they didn't, the insurance company did not initiate any actions. The other person did not hire a lawyer to initiate any actions against the client. So our client's not even a defendant in anything. So in order to win an accident case, DPS to win an accident case, they have, it's preponderance of the evidence. It just has to be, actually, I feel like it's even less than that, because it says it just has to be a judgment is likely. That almost sounds like probable cause, right? Like a judgment is likely that the other person's going to win. Now, the way that it would be likely is through the accident report or through the fact that your client got a ticket along the lines of a moving violation. But other than that, it's really not going to show anything. And so a lot of times the judges will look at the fact that anything was filed at all, and they're actually lean towards holding your client an affirmative finding, because they're going to be like, well, your client didn't file the SR22 and your client didn't pay the reinstatement fee. I'm going to give them time to do that. And say, wait a minute, judge. Wait a minute. I know we're not relitigating this, but when I look at the evidence, I don't even see an accident on the abstract record that DPS provided. They have to at least prove to me that there was an accident. Oh, it says it on the petition, but the petition is not evidence. And then that's when the judge will kind of get mad at you and say, they're just going to refile it. I don't care.
Okay.
I just want a negative finding. But that's why the prevent defense, you want to come in with your linebackers and safeties, go in there, try to get all of this stuff handled beforehand, and then just say, look, plain and simple, either get the other insurance company to say it was no fault, right? Because they're not going to say, oh, now it was actually their fault, right? They're going to say, oh, no fault. Cool. I have the paper that says no fault. Bam. Now it's definitely going to be a negative finding. But majority of the time, I will admit that the client will be at fault. So then it's just really like you have to speak to your client to see, well, how do they feel? They feel like a lot of times they just will feel like they were not at fault at all. And you can't really do much with that because it's like, okay, well, here's your choices. You can either pay them or not pay them. If they feel like they're not at fault at all, then the only real recourse you have is getting beyond the 2 years. Any other questions?
Just one. Thank you. By the way,
It could be another 10. Since I'm the president, we'll go on until you guys are satisfied.
No, it was a damn good presentation. Just one thing, the repeated admonition that the court will not relitigate.
Yes.
When we're talking about an accident case, every JP court that I've been, if my client is there and the other parties aren't there to say, well, he hit me or otherwise, it is relitigated. I've never had a JP argue with me about, well, I'm not here to decide whose fault it was. In fact, every one of it is it's a little civil accident case.
Okay, so the way I would describe it is, at no DPS suspension hearing is the party claiming that $3,000 that's owed to them, they don't have to show up at all. So that's what I meant. It's a paper case. So that's why you're not going to get to relitigate it, because there's not going to be like, the DPS is not going to say, I'm calling so-and-so as a witness to prove up that it was this person's fault. There's not even going to be any kind of depositions, anything like that. So it really comes down to what's on the paper. The only thing that's on the paper is what's alleged in the petition, but the petition is not evidence. So then it comes down to the evidence, which is usually the abstract record. And sometimes let's say, if we put ourselves in the position of, if I was a DPS person, I would come with the abstract record, I would come with the ticket, I would come with the accident report, and I would come with the documents that show that the insurance company attempted to collect, sent over, and how much it costs. Because all this is admittable. They just able to admit all of this because whatever the administration code just allows this paper stuff to come in without, as long as DPS stamps it. We received this evidence on this date, and then they shared it with us. They're able to bring it in. It's kind of like the same ALR situation. And then that's how they should be able to do it. But if they don't provide it, then it's like, did the accident happen? I don't think so.
Ruben, can I jump in here for a second?
Earl.
Okay, this is what I want to say. You're absolutely correct 100%. And you don't need a cheerleader. You don't need me to tell you that. You are absolutely correct. But what I want to say is you have to be careful, if I might add, you have to be careful not to prove their case for them. You are bringing the documentation, but you keep it there. You are under no obligation.
Oh, yeah. Earl, what I was saying is that if I worked for the DPS, that's what I would do.
I know. I heard you. I heard you correctly.
Not do that. So what I do is I gather all this information, and just like Earl said, I'm not introducing anything. I'm not going to introduce one document.
Nothing.
Unless they gave me something and I'm like, oh, I'm stuck. But I'm not going to introduce any ticket. I'm not going to acknowledge that the accident existed if the abstract doesn't show that there was an accident.
Right. This is the problem that you have with a lot of young lawyers, is that they overthink it and they over prepare it. And that's what they do, is they bring this documentation with them, and then they start introducing this stuff, and DPS is just sitting there and they're smiling. So I'll just shut up now. That I've made my point.
What I'll say is where a lot of people make the mistake is because of the actions of the judges, right? The judges start asking us questions like as if to prove it, right? They're like, well, did they pay the other people? Was something filed? I'm like, I don't want to talk about any of that stuff. What are you talking? Why are we talking about this stuff? That's to me, that's improper, right? Because if we're just really dealing with this stuff, it's simple. Judge, first thing I want to know is, like, I try to set it up where I say something along the lines of, Judge, has the DPS rested their case? Try to see if they rested their case. So the only evidence that they're introducing is the abstract record? Yes. Okay. Judge, there's no accident on the abstract record. The petition, and I always remind the judge, the petition is not evidence. It's an allegation. So there's no accident on the abstract record. I don't actually say your abstract record. I say the driving record that they provided doesn't have an accident. And they have not provided anything else.
Do you ever run into somebody on the DPS staff who's sharp enough to say, well, there's no accident record here, but we have this failed to control speed case from date XYZ, which is what we're talking about?
They cannot introduce. Yes, but even if they do, David, they have to be careful how they admit, because civil rules of evidence do apply in this type of situation. Ruben is correct. The civil rules of evidence apply, and there are certain protocols that they have to follow. You have to be given the opportunity to see what it is that they're showing you, and then you still have the opportunity to object. You can do an oral motion in limine if you want to, or whatever you want to call it. We call it protective order on the civil side, but never mind about all of that. What Ruben is saying is this. I just want to throw in one comment and then I'll shut up. The problem that we have today, and David, you see this every damn day, is unfortunately in Texas, you do not have to be a lawyer to be a justice of the peace or a municipal court judge. And what happens is a lot of times these people that are sitting up there in these positions, they don't know shit about the law. They don't know everything. And where Ruben is coming in is, it's the same thing with you, David. You have to try to explain the law to these people. They become very defensive about it. Even the constitutional county court level, you do not have to be a lawyer, as I found out in Madison County. Anyway, that's the problem, is you get to a point where you try to educate these people. The best thing to do, and Ruben is right, it's almost impossible to appeal most of these type of hearings. So the best thing to do is to go for the sure thing. If you can't get the negative finding, go for the probation and try to predicate your case this way, and don't try to piss off the DPS person, because you're going to see them again and again and again and again. The goal here is to protect your client and to try to get out of there with something that resembles a dismissal. Would that be a fair statement, Ruben?
Yes. What I would say is a lot of time, Earl kind of went a little bit further than I would go, as far, because a lot of these judges are civil judges, but it's administrative rules. So it's a civil rule. And so they might be used to, the sense that I get is they treat it like a motion to suppress, right? A motion to suppress, a judge is able to ask questions and cross-examine people and stuff like that. So the judge will just start asking you questions. And so it's not as formal as it should be. You're not going to get you could do an appeal, but it's going to be a big deal. And really, a probation finding is a win, because the only thing that you need, the only payment that will ever come out is the $100 reinstatement fee to DPS. There is no court cost, just plain and simple. So if you lose, reinstatement fee, bam, you turn in whatever documents. The hardest thing is the actual suspension, because then you got to get an occupational driver's license. But other than that, it is just plain and simple. It's a probation with no real teeth, right? It ends up saying no new tickets, and then that's it. But there's no court costs. They don't have to come out of pocket and pay somebody something right then and there. It's just, okay. But when you're making the arguments and you really don't have, like, a lot of the arguments that I'm telling you, these are winning arguments, but they're also like, the facts are bad for you. And so then it's a lot of little technicalities like, hey, if there's no petition, why are we here? But you know that when you spoke to your client, they were at fault for the accident and they just can't make the payment. So, okay, well, delay until we can do the SR 60. Right? The ticket stuff, most of the time you go in there and if you see 4 tickets within 2021, whew, that's gonna be real tough, especially if they paid it. So you just go in there and you say, Judge, he just didn't hire a lawyer. He didn't understand, or she didn't understand what was going on. So they thought they were doing right, but they didn't realize that they were just gonna get their license suspended. Can we just get a probation? Most of the time, sure, probation. End of story. And
I hear what you're saying. What I'm getting at is what I'm getting at is a little different thing. What I'm trying to find out, or what I'm trying to say is that although the abstract may show an accident and may show that there was a citation, if you go to trial on that citation and win or get it dismissed some other way, then even though that citation is on the record as having occurred, it isn't a conviction and therefore should not have any probative value as far as the underlying record is concerned.
If that were the case, what I would end up doing is I would ask for a reset. And then I would ask for a new abstract. I think you got to give it like 10 days, right? Because then it'll just disappear. And that's the only one that they can use. That's the only one that they can submit. And then it's like, what are you talking about? There's no evidence that it's on there.
Okay. And the last point I wanted to make is that the fact that you get a citation for something is not determinative of fault in the accident. They're just completely apples and oranges. The insurance companies don't see it that way. And I guess the DPS doesn't either, but that's not the law. So,
well, it's based on what the statute says, that the judgment is likely, right? And so so they use that as the argument, and since it's only preponderance of the evidence, that's why you'll end up kind of with that affirmative, but it's usually affirmative probation. Because if they turn in the SR 22, right, and they have anything and they've done anything else, then you're gonna win. And all you really have to worry about is some kind of probation, right? But the majority of the accident cases, I get them to do like an SR 19 if it's a year out before the 2 years, then I can't get it. I can't keep resetting it for another year. I mean, unless it's like COVID, right? But barring another crazy courts closed for 9 months, it's not going to happen. So then I get them to work it out some kind of way, file an SR 19, and then that's it. Or sometimes I just make the promise, Judge, they're going to fill out this paperwork, and the judge says, affirmative finding probation for this many times, and they have to turn this in. If they don't, then it'll go into an indefinite suspension. And then that's it. Any other questions? Happy holidays. I see a lot of people saying happy holidays.
we appreciate your time.
No problem.
Happy holidays, everybody. Have a nice holiday. Great presentation as usual. And it was really very, very, very great CLE and everything. Hope you feel better, Ruben. And everybody, same thing. Be safe. And we'll see you soon.
Thank you very much. We really
All right, let me repeat
Thank you,
that
Great CLE.
Amount, and then I'm going to stop the stream and the recording. 174143